Hello, this presentation is brought to you by Jurmenson & Cobb, PA. The title of this presentation is The Bankruptcy Code's Automatic Stay. And your narrator is Hans Wall. I'm an attorney at Jurmenson & Cobb. Now, the roadmap for this presentation, we'll begin with an introduction. We'll go over the definition of the automatic stay, and we'll discuss how it is a benefit to debtors and a detriment to creditors. And the automatic stay is codified in Section 362 of the Bankruptcy Code, and we will then go over an overview of that section. We'll do the breakdown of Section 362A, the areas of Section 362 most favorable to creditors. We'll then discuss secured versus unsecured creditors, and we'll break down the sections 362B, 362D, and 362F. And we'll also provide some case law examples of this section in action. From there, we'll discuss the consequences of automatic stay violations, providing examples from case law, and we'll conclude with some takeaways. Now, the automatic stay works as an automatic injunction, which halts actions by creditors and potential creditors to collect on pre-bankruptcy debts from a debtor who has declared bankruptcy. The automatic stay takes effect immediately upon the debtor filing for bankruptcy, and it applies in Chapter 7, 11, and 13 cases. The automatic stay, it is a benefit to debtors because once it is invoked, it works to immediately cease the continuation of actions and/or proceedings by creditors to recover claims against the debtor. And there are a few exceptions we'll discuss. The automatic stay also works as a detriment to creditors because they can no longer continue with collection efforts and/or legal action to try to collect on their claims against the debtor. And ultimately, the reason for the automatic stay is because it's a blessing to trustees, because what it does is it freezes the debtor's estate and assets at a single point in time, and that single point in time is the filing of the bankruptcy action. And the point of it is so that the trustee of the bankruptcy action can effectively value the estate, evaluate all the creditor's claims, and perform his or her duties as the trustee. As previously mentioned, Section 362 of the Bankruptcy Code is where the automatic stay is contained. It's a lengthy section of the code, and I'll do my best to try to break it down for you. Section 362A 1 through 8 will explain who and what the automatic stay applies. Then Section B 1 through 28 provides for several exemptions to the automatic stay. Section 362C 1 through 4 explains how long the stay is in effect, what subsequent acts or occurrences work to end the application of the automatic stay, and it will also set forth the criteria for a party in interest to make a motion for continuation of the stay in particular cases. And Section 362D 1 through 4 allows for a creditor to request from the court relief from the automatic stay when the automatic stay would normally apply to the creditor because its claim doesn't fall under any of the exceptions provided for in Section 362B. And finally, 362F. This allows for a party in interest to request relief from the stay in order to prevent irreparable damage to a debtor's property. Now, regarding Section 362A, the automatic stay immediately ceases the following actions against the debtor. It will cease the commencement or continuation of a judicial, administrative, or other action against the debtor for a claim that arose pre-bankruptcy filing. It will stay the enforcement of a judgment obtained pre-bankruptcy filing. It will stay any act to obtain possession or control over debtor's property, such as repossession. It will automatically stay any act to create, perfect, or enforce a lien against a debtor. It will automatically stay any act to collect, assess, or recover a pre-filing claim against a debtor. and the set-off of any debt owing to the debtor against any claim against the debtor. That is stayed as well. And finally, the commencement or continuation of proceedings to recover a tax liability from a debtor is also stayed. The automatic stay will halt foreclosure proceedings, wage garnishments, utility disconnections, continuation of civil lawsuits, and the repossession of most property. Okay, now we'll transition to discussing sections 362B, D, and F, which are the areas of this section that are most applicable to creditors for circumventing the automatic stay, and as a result, you can call them the creditor's friends. Now, a creditor's perspective of avoiding the automatic stay, this is the order in which such ways of circumventing the stay should be analyzed. 1. Is the creditor and or the claim exempt from the automatic stay under section 362B? If not, does the claim and or circumstance allow for the creditor to request from the court relief from the automatic stay under section 362D? If not, can an argument be made under 362F that there will be irreparable harm or damage to a debtor's property in which the creditor has an interest if relief from the stay is not granted? Now it would be appropriate to discuss the difference between secured and unsecured creditors. There are several ways in which a creditor could be secured. The first is you have a creditor whose loan to the debtor is secured by collateral pursuant to an enforceable contract, such as a car loan, a mortgage. Or you may have a creditor that got a judgment against the debtor and levied and perfected that judgment against an item of the debtor's property. Technically, that type of creditor is called a judgment creditor, but judgment creditors do have more protection than unsecured creditors. An example of a judgment creditor would be, let's just say, a general contractor who did a room addition to a person's home, was never paid, received a judgment lien against the homeowner, and then recorded that lien so that his or her judgment was perfected against that property. Unsecured creditors, that is a creditor whose loan to the debtor is not secured by any collateral or interest in a court-ordered judgment. Almost all unsecured debts are discharged in bankruptcy, and these would be items such as credit card debt, services received but not paid for, and judgments that aren't levied or perfected. Now, secured creditors have a better chance of avoiding the automatic stay, and that is because secured debt is not discharged in bankruptcy, but unsecured debt is. So in other words, a court is not going to allow the unsecured creditor to avoid the automatic stay for a debt that would just be discharged anyway. Now, there is a type of creditor called an undersecured creditor, and this is a creditor that holds a secured claim to the extent of their collateral and an unsecured claim for the deficiency. So, for an example, a creditor may have a claim against someone for $300,000, but the equity in the collateral is only $200,000. So, in that situation, the creditor would be secured up to $200,000 because that's what the collateral is worth, and that remaining $100,000 will be undersecured. All right, we'll transition to now discussing Section 362B, and these are exemptions to the automatic stay. Now, Section 362B1 provides an exemption for criminal actions, proceedings against the debtor. Of course, you can't file for bankruptcy and think that the state's not going to prosecute you if you committed a crime. Criminal actions against the debtor will continue. There's also an exemption to the automatic stay for family obligations, such as alimony, child support, things like that. A person cannot file for bankruptcy as a way to avoid paying child support, as an example. Section B4 are actions by a governmental unit to enforce its police or regulatory powers. Section B6 is obligations pursuant to the ownership in financial securities. And Section B9 would be tax obligations to the U.S. government. Section B10 would be an exemption for a lessor's actions to regain control over commercial property due to a lease expiration. And section B21 and 22 would be an exemption regarding an eviction action for residential property if the lessor received a judgment for possession of such property before the debtor's filing of bankruptcy. And eviction action is based on the endangerment of such property or the illegal use of controlled substances on such property. Now, section 362B is quite lengthy, but here I provided several examples of probably the most used and popular exemptions to the automatic stay. Under section 362D, this provides the creditor the ability to ask the court for relief from the stay, and it also provides for the procedures the creditor must follow. If a creditor desires to continue collecting from a debtor during bankruptcy, the creditor can petition the court for a lifting of the stay or relief from the stay. To do so, the creditor must file a motion with the court. The debtor is then entitled to notice and a hearing regarding the creditor's claims and reasons for continuing collections. At the hearing, the creditor has the burden to convince the court that it has a sufficient reason for lifting the stay. And keep in mind that this remedy is usually never granted for an unsecured creditor whose debt will ultimately be discharged in bankruptcy. These provisions under 362D are for secured creditors. Okay, now under 362D, the creditor can petition the court for relief from the stay if the creditor is lacking adequate protection in the collateral. Adequate protection. What this is, a secured creditor's interest must be adequately protected if its assets are still in the debtor's possession. So what you have is the debtor has filed for bankruptcy, is still in possession of the collateral, and the creditor is no longer able, because of the automatic stay, to pursue collections against that debtor. So the creditor still is afforded some protection, and that is considered that is called adequate protection. A lack of adequate protection usually means that the debtor is no longer making payments on the property or collateral, and there is no insurance on that property or collateral, which was used as the underlying collateral for the creditor's loan to the debtor in the first place. An undersecured creditor has a right to adequate protection up to its secured amount, but not for its unsecured amount. So in the previous example, if the creditor has a claim for $300,000, but it's only secured in the collateral up to $200,000, the undersecured creditor has a right of adequate protection up to that $200,000, but not for the $100,000 unsecured amount. Unsecured creditors do not have a right to adequate protection at all for its unsecured claim. And here's an example. Let's say that because of the sales contract signed by the debtor, the car dealership has a secured interest in the truck it sold to the debtor 2 years ago. If the debtor files for bankruptcy and no longer makes truck payments or pays his or her insurance on that truck, then the dealership's secured interest in that truck is no longer adequately protected, and the dealership, as a result, can seek relief from the automatic stay under Section 362D1. Now, under Section 362D, here are some other instances in which the creditor can petition the court for relief from the automatic stay. The creditor can do so if the debtor does not have any equity in the property that a secured creditor has an interest in, and such property is not necessary for reorganization if this is a Chapter 11 bankruptcy. And the creditor can petition the court for relief from the automatic stay if it involves debtor's real estate that the secured creditor has an interest in, unless the real estate is part of a Chapter 11 reorganization, or the debtor has continued making monthly payments on it. And the creditor can petition the court for relief from the stay if it involves a debtor's property in which the creditor has a secured interest, if the court finds that the debtor's filing of bankruptcy was part of a scheme to delay, hinder, or defraud the creditors that involved the transfer of ownership of that property without consent of the secured creditor. And we'll now move to Section 362F. This is a section that will also allow the creditor to seek relief from the automatic stay in certain situations. Here, a party can request the court, which the court can do with or without a hearing, the court can grant relief from the stay if it is necessary to prevent irreparable damage to the property, if that damage may occur before there is opportunity for notice and a hearing. And a few examples here of where this was placed into action. Under the first example, the court did grant relief from the automatic stay under Section 362F, where it was necessary to allow a continuation of a mortgage foreclosure proceeding regarding a shopping center, where irreparable injury was going to occur to that shopping center unless there were structural repairs undertaken, and because the structural engineer threatened closure if the repairs were not met. Now, there was another situation where the creditor did not win its motion for relief from the automatic stay. Here, the bank alleged that the debtor may remove funds from a checking account that the bank was going to use as a set-off for amounts owed, but the court said the bank failed to establish irreparable damage, or that there even was a likelihood of success on its merits, and thus it was not entitled to lifting of the stay. Here, there was no suggestion that the debtor had made any attempt to use the funds in the account, and the bank failed to provide documents in support of its claim that the debtor owed it $138,000. So in that situation, the creditor failed to achieve the entry of relief from the automatic stay. It's important to keep in mind that irreparable harm in the bankruptcy context refers to harm to the interest of the creditor or to the bankruptcy estate itself. Of these two, the irreparable harm to the bankruptcy estate is the greatest relevance to the court, and that was held in the case of In re Lichtman, which came out of the Middle District of Florida. And here's some other case law examples. In one case, granting landlord immediate relief from the automatic stay was warranted so as to allow landlord to continue action against the debtor for repossession of property, because the condition of the leased premises posed a threat to public safety due to it having no power, the emergency lighting was inoperative, and there was a lack of air conditioning, which posed immediate threat of mold. Under the second bullet, here's another example where the city of Jacksonville, Florida was allowed under an exemption pursuant to 362b-4. It was allowed to get relief from the automatic stay to demolish a housing complex that was condemned as a fire hazard, even though the landlord had filed for Chapter 7 bankruptcy and the automatic stay was in effect. The city here was exempt under the police power exemption, and therefore it could demolish the landlord's property. And under that last bullet, this involved default on rent payments. The landlord terminated the lease. The tenant had a grace period to cure default, but it did not. And right when the grace period ended, the tenant filed for Chapter 11. The landlord then sought relief from the automatic stay to evict the tenant. The court held that the tenant defaulted and failed to cure the default during the grace period, which was all prior to the filing of the bankruptcy action. Thus, the landlord was granted relief from the automatic stay under Section 362d-1 in order to proceed with eviction proceedings. And a couple of more examples of how the automatic stay works and how relief from the automatic stay may be obtained. In this first example here, the value of the debtor's boat, based on an ordinary sale on an average market, was deemed to be $140,000. However, at the time there was extremely soft market conditions, and it was doubtful the boat could be sold for that amount. The principal amount owed to the secured creditor of that boat was $120,000. At that time, the debtor had no income, and the court held that this court is satisfied that due to the debtor's nominal equity in the vessel, the soft market condition, and the debtor's lack of income with which to make adequate protection payments, the creditor is granted a modification of the automatic stay. So what happened there is the amount owed to the secured creditor was $120,000, and the debtor said, well, this boat is worth $140,000, so the creditor is fully secured in it and relief should not be granted for him to repossess the property. However, the court then said, well, that $140,000 figure is if we're in an average market, but right now we're not in an average market, and the debtor and the creditor is undersecured as a result. And because the creditor was undersecured, the court said that due to the debtor not paying the adequate protection payments, the creditor was allowed relief from the automatic stay. In that second bullet, there was a conversion of a bankruptcy case from a Chapter 11 to a Chapter 7, and the court held that that does not trigger the automatic stay in such a way as to result in the reimposition of the stay against the parties that were previously granted relief from the stay. So if there is a bankruptcy proceeding and a creditor is granted relief from the stay, well, the debtor cannot then try to convert the case from a Chapter 11 to a Chapter 7, for example, as a way to try to reinstitute the stay against that creditor who already obtained relief. And in the bottom bullet here, there was a creditor that had not been scheduled as a creditor on the Chapter 7 debtor schedule. So when a debtor files for bankruptcy, he has to file schedules with the court that lists all of his creditors. And the debtor did not list this particular creditor on that schedule. And that resulted in the creditor having no notice or knowledge of the debtor's bankruptcy. And the court, and the issue was whether or not the creditor violated the automatic stay. The court said that the creditor did not willfully violate the automatic stay in moving for a default judgment against the debtor in a state court litigation that was pending currently with the bankruptcy action. The court said that this was not a willful violation of the stay because the creditor didn't have any knowledge of it. However, the court held that the creditor was still liable for sanctions for willfully violating stay based on its subsequent actions. So it was eventually notified of the bankruptcy, of the debtor's bankruptcy, but the creditor failed to take steps in that state case to undo the default judgment that it sought. And as a result, the initial action was not willful, but the court held that subsequent actions by the creditor were willful. And it's not good to violate the automatic stay. There's some bad consequences that can result from that. But it's necessary to keep in mind that actions taken in violation of the automatic stay are void and without effect. And this is true if there is even no actual notice of the stay. So first things first is, even if you don't know about the stay, you're a creditor, even if you have an excuse in that you had no idea, so it wasn't willful, any of your actions that were taken during the bankruptcy are going to be void and without effect. Now, the second thing to keep in mind is that the court has the power to cite a person who violated the automatic stay for contempt and to impose an appropriate sanction to indemnify the debtor for injuries suffered as a result of a willful violation of the automatic stay. And here's a couple examples. There was a creditor who repossessed a car without knowledge of the bankruptcy. Well, this wasn't willful because the creditor did not have knowledge of the bankruptcy action. The court held that the creditor still had a duty to return the vehicle and to reestablish the status quo as of the day of the filing of the bankruptcy petition. As another example, there was a creditor whose claim was secured by interest in the debtor's car, and it was held that the creditor willfully violated the automatic stay by repossessing the automobile after the debtor already filed for bankruptcy, and the creditor had noticed that the automatic stay was in effect. The creditor, even though he knew of the bankruptcy and knew the automatic stay was in effect, still repossessed the car. The court held that was willful, and the debtor was entitled to damages, including a punitive damage award of $35,000. All right, and as we conclude, here are a few more case law examples of reasons why all creditors should beware of violating the automatic stay. First, in this first example, all the secured creditor did was threaten to suspend its reporting of payments to the credit bureaus if the debtor refused to reaffirm the debt after its bankruptcy action had been discharged. So what happened was the debtor was making payments, filed for bankruptcy, All the secured creditor did was say it just threatened. It didn't do any action. It just said it just threatened to suspend reporting of those payments if the debtor refused to reaffirm the debt. The court said that just that threat was still a violation of the automatic stay. As another example, it was held by the court that the bank willfully violated the automatic stay when it knew it had been given notice twice that the debtor filed for Chapter 7. But still, the bank proceeded to take money out of the debtor's bank account. The court said that that was a willful violation of the stay, and it awarded the debtor $20,000 in punitive damages. In another case from the Middle District of Florida, the court held that a company's post-petition billing statements that it sent to the debtors were attempts to collect the pre-petition debt. It sent statements knowing the debtor had filed for bankruptcy and the automatic stay was in effect. And the court held that each post-petition statement that the creditor sent to the debtor constituted a separate violation. The court held the debtor suffered actual damages, including attorney's fees and costs, and it awarded punitive damages as a result. And in this final example, the court said that the creditor violated the automatic stay when, with knowledge of the debtor's bankruptcy, the creditor repeatedly sent invoices to the debtor advising it of the amount of its delinquency and requesting payment of that amount. The creditor tried to hang its hat on the fact that there was a paragraph in the invoice where the creditor acknowledged the debtor's bankruptcy and stated that in light of the debtor's petition, the invoices were intended for informational purposes only, but the court was not amused by that. The court said the fact that you still sent these invoices to the debtor attempting to collect this debt after the debtor filed for bankruptcy, that is still a violation of the automatic stay. And that now concludes this presentation on the Bankruptcy Code's automatic stay. On behalf of Jimerson and Cobb, I would like to thank you for your interest and for viewing this presentation.